Here's this week's question of the week. I filed for disability and my doctor did all the paperwork saying that I can't go back to work. But now they've denied me because they claim to have a different doctor saying that I can work. What's going on and what can I do? It's very common for two different doctors to give very different opinions about your ability to work when you have a Social Security disability claim. In fact, most every Social Security disability claim that I've handled over the past 20 years has involved conflicting medical proof or conflicting medical opinions. If you have been denied Social Security disability by the Social Security Administration, the first thing that you need to remember or be aware of is that most of the time you have a limited period of time to appeal the decision of the Social Security Administration. Most every denial involves you having a 60-day period of time from the date that you receive your denial to appeal that denial to the next step. If you have applied for Social Security disability at the local office of the Social Security Administration and you've been denied for the first time, your next step is to apply for reconsideration of your denial. If you file what's called a request for a reconsideration, it's a special form that you can find on the Social Security Administration's website, or you could get it from an attorney. If you file that form, you're asking them to reconsider their decision, and the Social Security Administration will look over your file. They'll look at the decision where they denied you and see if there's any reason why they should overturn their own decision. Most of the time when the Social Security Administration gets a request for reconsideration, they deny that request for reconsideration. So you can pretty well expect that you're going to get denied a second time. If you have been denied 2 times for Social Security disability, the next step in the process is to file what's called a request for hearing before an administrative law judge. A request for a hearing is asking the Social Security Administration to have an administrative law judge, usually somebody who's an attorney and now a judge, to review your denial and determine whether you are entitled to Social Security disability benefits based on his or her review of the file. The Social Security Administration, upon the receipt of a request for hearing, is going to assign your case to an administrative law judge. That judge is going to review your file. The Social Security Administration will set a hearing in front of the judge where you will go before the judge and give testimony about your inability to work. The judge may or may not ask a vocational expert to attend the hearing and to look at your file and present testimony about your ability to work based on what the doctors have said. If he does appoint a vocational expert to come to the hearing, it would be even very critical that you retain an attorney who is very experienced in Social Security disability claims to represent you at that hearing. An experienced attorney is going to know how to assist you and present your case in the light most favorable to your claim. An experienced attorney is going to know how to develop the medical proof in the case and attack the testimony of the evaluating physician in that case. An experienced attorney is going to know how to present the testimony or the reports of the treating physician in the light most favorable to your case to help you get approved for a disability. In most cases, the Social Security judge is going to give more weight to the treating physician's opinion over the opinion of the evaluating physician. I have a very active Social Security disability practice. I don't charge any fees up front. I don't get paid unless I get your claim approved. Let me help you get your Social Security disability benefits and help you get your life back.
Get your life back. Call the law offices of T. Verner Smith for a free consultation. 423-1888. 423-1888.